tell you guys, I do see a few familiar faces here. So you have been a part of our previous training series. But what exactly is RSIL and why are we taking this initiative on these training series? RSIL is Research Society of International Law, is actually the only legal think tank in Pakistan and I think also in Asia which is working on creating awareness of about international law. And one of the ways through which we actually implement, because we don't only research, we aim to convert all our research into action, and this is one way through which we actually do it. And this is, so I hope all of you enjoy it, all of you learn as much as possible from it, and please note down your questions because it's going to be hard to get this panel in one place once again. So before I start, of course, I would like to invite Sir Sikandar Shah. He will be moderating this entire event. He is a professor of law at LUMS. He's also been a legal consultant, a legal advisor at the Ministry of Foreign Affairs. Sir Sikandar, can you please come on stage? Right.
Assalamu alaikum everyone, ladies and gentlemen. It's a pleasure to be here. I have been associated with RSIL for over 10 years. And I would say that there's no other place where international law is appreciated more than this place, you know, and the practice, the theory, both of them, right? And so, I mean, from here I moved on to the Foreign Ministry and I'm associated with LUMS, and I would like to say that this panel is absolutely brilliant. I'll be introducing them in a little while. They probably collectively know more about environmental law than any other place in this country. And you know, the role of the environment, as you all know, is highly important, and how it is regulated now through the various mechanisms. I understand that the conference is focused on Pakistan and how the legal framework has evolved or is evolving or is strengthening. But I mean, and people look at it differently. So I mean, just quickly, I'm curious about this, and I would like to urge the speakers also to tackle this issue, because I'm extremely curious about how this will pan out as we move along, because I see all this pollution and beyond that, little recognition as a developing country with all this commercialization happening. But from an international perspective, I see different approaches to how the environment is being tackled. Like, there's a human rights approach to the environment. There is I would say, a commodification of the environment through private enterprises in looking at the environment and protecting the environment. And then there's also this intra-state mechanism where states exchange credits to regulate the environment. So I mean, there are so many angles to this, but I would be curious to perhaps understand when we're discussing the local context and the legal regimes and the EPA, but also to tackle these questions from a global perspective as well. So before we move on, I would like to introduce the speakers. Again, all of these people I know, or I've interacted with, or I've learned from. Absolutely brilliant panel, but you know, and so there's no sort of hierarchy here. I'll just go along with what's been given to me. So you know, first of all, Rafay Alam, of course, you know, I've interacted with Rafay from actually even before that, from HSN. So not gonna go into all of that, but you know, he's, as you know, he's one of the most recognized and environmental lawyer in the country, and he's brilliant. So I'm going to read this, but you know, I mean, Rafay Alam is an environmental lawyer and an activist working in Pakistan. After a decade of practice ending as senior associate to Dr. Parvez Hassan, in 2013, Rafay merged his experience in civil, corporate, and constitutional law with his passion for public interest environmental litigation, and co-founded Saleem Alam & Co., a law firm that specializes in energy, water, natural resources, and urban infrastructure. Rafay writes regularly in a host of newspapers in Pakistan. I see pretty much every major newspaper he has written in or he writes in, and others that are in the region and even beyond. Sufi Saab really needs no introduction, but I will still introduce him. No, but you know, he.
I'm a lawyer.
he's lawyer Lawyer in capital letters. Okay, but there's absolutely so much respect for him in the legal community, in the international law community. He's represented this country at international fora, including the UN. I've actually accompanied him in some of these sessions, and he has not only looked out for the interests of Pakistan, but human rights holistically. Ali Sultan, a friend who also has been, I've known him, from HSN. He was appointed as the Vice President of RSIL in March 2016. Earlier, he served as the Executive Director of RSIL from 2012 2016. He's supervised numerous projects on the criminal justice system and counterterrorism and police reform. He also is a colleague at LUMS. He teaches business law as a professor at the LUMS Business School. And apart from that, he has given academic lectures and held appointments at numerous other centers of learning, including the National Management College, Punjab Judicial Academy, Lahore, Naval War College, Lahore, Punjab University, and NDU. Fahad Malik, I've interacted with Fahad Malik again from LUMS. He was one of my best students, but now he is probably, I was actually talking to him and discussing how he can help me teach environmental law next semester. He's a graduate of LUMS and a licensed attorney of the High Court. Over the past 3 years, he has worked extensively in the field of oil and gas and is well versed with laws relating to the energy sector. He has considerable experience in banking litigation, as well as has pioneered the firm's SOPs for executing decrees. Fahad Malik also has considerable knowledge and experience of litigation under the accountability laws of the country. He regularly assists our senior consultants in drafting pleadings for the Supreme Court. I'm assuming that's for, he has worked as a consultant in various capacities for a number of national and international institutions. And he's written reports for various bodies, inclusive of the Supreme Court of Pakistan, ADB, the ministries, including the Law and Justice Ministry. He's worked with the IUCN, and he has also worked on land acquisition laws in Pakistan. Mr. Osama Malik, lovely to meet you, is a partner at HCU Legal, a leading law firm based in Lahore and Islamabad. He holds a master's in international development and human rights law from the University of Warwick. He also is serving as the chairman, International Legal Affairs Committee, the Lahore High Court Bar Association. Farhan Awan is the chief executive of Acro Green Company Limited. This is a corporation, a company which focuses on environmental consultancy and has an unrivaled reputation for providing high-quality tailored services. Acro Green has worked with numerous clients to help resolve their most demanding environmental issues. At Acro Green, they combine resources across technical and scientific disciplines to provide their clients with the best, most responsive solutions, whether responding to existing challenges, evaluating opportunities to improve performance, or seeking to reduce future liabilities. So I welcome all of our guests, and let's have a round of applause for them. I think how we plan to structure this session is that we will have some of our speakers come here and give a few presentations, and then we'll have a sort of an interactive session where I'll be raising certain questions, where all of them will be responding to, and all of them will be interacting with each other and with all of you. So let's start this, and let's have Rafay Alam initiate this amazing conference. Thank you.
Thank you. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum ji. RSIL, thank you so much for inviting me. Sikandar, thank you for a fantastically, but I think overloaded introduction. Thank you though. I'm an environmental lawyer in Lahore ji. I don't know much about international law. But I have come today to ask you a bunch of questions on international law. I've actually been waiting for this opportunity to give this presentation and raise these questions. Hello? Hello? Okay. So I had the opportunity to work with the government of Punjab last year on a restructuring of the Environment Protection Department, and one of the questions that was in our work was the question of multilateral environmental agreements, MEAs. So that's what my presentation is about. It's going to focus on environment through the lens of these multilateral environmental agreements, and you'll be surprised the types of issues that are going to come out of this discussion won't really have to do with environment as we are aware of it, or the smog outside, but I have brought another presentation so I can show you stuff later on, but really my point was to be able to raise these questions. All right, I have two questions about multilateral environmental agreements and frankly all international agreements that Pakistan signed. Who and what? You know, who is to implement them, and what are we to implement? These are my two questions, because I'm very, very confused. Next slide, please. But first, just a bit of introduction. I'm sure you're all familiar with this. This is Articles 1, 41, 42, and 44. They talk about federalism in Pakistan, that the executive authority of the federation extends to all of Pakistan, but is limited to the subjects in the federal legislative list. This is a departure from the pre-18th Amendment situation that we had, where we had a concurrent list, which is a departure from the 1956 constitution that we had, that had a federal, provincial, and a concurrent list, which is separate from the Government of India Act, which had something like this as well. But this spells out the federalism in Pakistan. This is the background argument here, that we have a system of governance with three tiers of governance: federal government, provincial government, and local governments. फेडरल गवर्नमेंट और प्रोविंशियल गवर्नमेंट की बहुत एलैबोरेशन है, प्रेसिडेंट होगा, गवर्नर होगा, असेंबलीज होंगी, इस तरह कानून बनेगा, बजट होगा. बट लोकल गवर्नमेंट के बारे में एक फिक्र है, आर्टिकल 140A, दे शैल बी इलेक्टेड लोकल गवर्नमेंट्स with decentralized powers. But this is the way the Constitution spells out the responsibilities for legislation and executive authority. It's really the federal legislative list. And if you don't like it, if the provinces are out of capacity, if they don't like this formula where, you know, they feel they don't have the capacity, for example, in seeds, which is the Seed Act of 1976, they can use Article 144, which is when all the provincial assemblies, or it used to be all the provincial assemblies, but after the 18th Amendment, it's just one provincial assembly, can request Parliament to make a law on a subject in the provincial domain. So we have a system of federalism that recognizes different tiers of governance and a decentralized system, which I'll come to in a little bit, but it's not a one-way street. It goes both ways. You can use Article 144 and have laws sent up to the Federation. Not everything has to be decentralized. Another example is the National Disaster Management Authority Act of 2010. After the floods, it was recognized that disaster management at that scale could not be done by the local governments, because disaster management is in fact a local government function. Civil defense is a local government function. But they don't have the money, neither do the provinces, plus you needed a federal coordinated activity for something as big as a national flood. And so the provinces requested Parliament to pass the Disaster Management Act. And it's it's about the time of the 18th Amendment. So it's one of the few, I'd say, 18th Amendment legislations, because the Act itself envisions a national disaster management authority, provincial disaster management authorities, and even district disaster management authorities. So it sort of recognizes the federal structure of Pakistan and proceeds along those lines. But that's by way of introduction. Back to the who. Who is to do this? So I've sort of indicated, is it supposed to be the Federation? And that's what they'll have you believe, because the federal legislative list has entries 3 and 33, which allow the federation to take executive action and then indeed make laws on the implementing of treaties and agreements, and also international treaties and conventions. And recently the Supreme Court of Pakistan in the Sui Gas case has held in relation to trade unions, because there are a lot of international labor agreements that we've entered into. So on the basis of that, the Supreme Court held that matters relating to trade unions and labor disputes, etc., having been dealt with and protected under the international conventions, are covered under entries number 3 and 32 of the federal legislative list, and therefore the federal legislature has legitimate competence to legislate in this regard. So it doesn't matter if it's a provincial subject. If there's an international agreement on it, the federation can step in as if the 18th Amendment didn't happen. And that's the little problem that we're cropping up with over here. But, you see, but, and I have several buts. So this is the Supreme Court. But, the first but, just one button please. The first but is, we have to see Article 144 and the entries in the federal legislative list in the history of our constitutional development. So you have to go back to the Government of India Act 1935. The Government of India Act 1935 has federal laws, concurrent laws and provincial laws. It also has a particular article that says that the state, the central government, shall have the power to implement international agreements even if the subject is in the provincial domain. There was a specific article in the Government of India Act 1935 that allowed the state, the central government, to reach in and make and implement an international agreement even if the subject was in provincial domain. The Government of India Act was Pakistan's first constitution. The Constitution of 1956 more or less copies the same thing. We have this federal list, the concurrent list, the provincial list, and the federation has the ability to implement international agreements. A specific clause of the Constitution allowing it to implement international agreements on subjects of the provincial domain. Then you have the 1973 Constitution, which does away with the provincial list. It only has the federal list and the concurrent list. You have to place the 73 Constitution in the trajectory of our constitutional development as a political evolution. We fought 100 years ago, just last week, hundreds of thousands of Indians sacrificed their lives so that England could win World War I. You know, there's an estimate of 75,000 Lahoris having lost their lives in World War I. And it was because we laid our lives down that the Government of India Act 1919 allowed concessions and some form of local governance to Indians. The English had to concede power because they were a colonialist. They did not believe in democracy. They were here as resource extractors. हमने खून देकर उनसे कहा कि जी ये हमें governance दे. फिर 1935 Government of India Act again was a negotiation. But we got more governance, more control. Government of India Act 1919 में उन्होंने governance तो provinces को दे दी, मगर diarchy भी साथ दे दी. Diarchy का मतलब ये है कि the governor could still retain legislation making powers. So they don't really giving powers to the people. So you look at it this way, and the 73 Constitution is the realization of a historical political plea of decentralizing control and governance to the people of India and to the provinces. Now if I can all jog your memory to Jinnah's 14 points in our favored Pakistan studies, Sindh should be separated from the Bombay presidency. Was nothing more than an aspiration that Sindh should be governed by the people of Sindh itself and not by sort of a governor general sitting somewhere else. So you have to put what the Supreme Court said in the context of this. First but. Next but. The Supreme Court does not refer to Rule 49 of the Federal Government Rules of Business, which state in black and white that the implementation of an international agreement in the provincial field shall normally be the responsibility of the provincial government unless a specific waiver has been obtained by the Prime Minister in terms of Rule 15(1)(c). And after the Mustafa Impex judgment, we know that the Prime Minister doesn't act alone. He has to consult with Cabinet. So a bare reading of the Federal Government Rules of Business, which was not quoted in the sui gas case, says that there is a presumption that it will be the provincial government that implements international agreements on subjects in the provincial field. Next slide. Second but. Third but. And this is the interesting thing. After the 18th Amendment, the subject of environment and natural ecology, which used to be on the concurrent legislative list, it was its position on the concurrent legislative list that allowed the Federation to enact the Pakistan Environment Protection Act of 1997. But after the abolition of the concurrent legislative list, all 4 provinces have exercised their newfound legislative powers and have enacted environmental legislation on their own. All 4 provinces have done so. But 3 of the 4 provinces have empowered their provincial assemblies to make rules for the implementation of international agreements. So 3 provincial assemblies have by law, so ye bhi Qanoon hai. So the 3 provinces are, these 3, Sindh has not done so. Sindh, in its 2014 Sindh Environment Act, says that the implementation of international agreements shall remain a federal responsibility. And it could be because the department in Sindh felt that it didn't have the capacity to be able to do things related to ozone or the laws of the sea or Ramsar. It could be that the federal government has the capacity and the resources, and so in their legislative wisdom, that is how they exercise their post-18th Amendment freedom, so to speak. And one more but, I think. Yes, the last but. That we have Article 144. And a reading of the 18th Amendment, you put it in its sort of constitutional historical context, Article 144 should be used. And here, if I just may, water as an environmental subject and now as a legal subject has really, 2018 has been the year of water law in Pakistan. But water is not in the federal legislative list. Never was. Never was. The first mention of water in our historical documents comes in the Government of India Act 1919, when it was a provincial subject. And it remained a provincial subject in the Government of India Act 1935. And it wasn't in the concurrent list in the 1973 Constitution. So if water is such a big issue, how come in our limited experience of democracy, no provincial assembly has ever exercised Article 144 on this subject? Where is the democratic mandate behind this concern for water? Don't know. Next slide, please. So that was just an aside on water. I can come to that in a second. There's yet another but. Because the Supreme Court was very comprehensive in the Sui gas case, going through a history of the development of the Government of India Act and the clauses related to the Federal List and so on and so forth. And it quoted almost all of the case law on the implementation of or recognizing federalism in Pakistan. But one of them really strikes me is the judgment in Sayyid Imran Ali Shah from 2013, where considering the 18th Amendment and considering labor laws, because we have a lot of international labor agreements, Justice Mahmood, I think his name was Mahmood Khan, talks about cooperative federalism. And I think this is where we're at, I think politically in so many ways, is where we're talking about a rollback of the 18th Amendment. इस तरह की बातें सियासी तौर पे हो रही हैं. But I think cooperative federalism is an area where we have yet to envision what our federation looks like after the 18th Amendment. We had a federation that was designed by the colonialists, which was top down. But after the 18th Amendment, after this abolition of the concurrent legislative list, it's a huge political step to take forward and a legal step to take forward. I still don't think whether we've understood just whether the federation and provinces are equal, whether there's still an inequality, whether it's top down, we don't know yet. So we're still in a grey area, and I think this is what one thing when you look at multilateral environmental agreements comes up a lot. Okay, who is to implement these? Because environment is a provincial subject. So who is to implement Pakistan's international environmental agreements? Is it supposed to be the federation, or is it supposed to be the provinces? And the same question can be asked in relation to the Pakistan Climate Change Act of 2017. Pakistan is extremely vulnerable to climate change, and it's a mark of pride that it's one of the few developing countries, or few countries in the world, that has a proper climate change legislation. Parliament ने Climate Change Act बनाया, but please find me climate change in the federal legislative list. Please find me the exercise of Article 144 where any province has said कि जी भाईजान आप इसको करें. नहीं है. Next slide, please. So moving on.
Was this judgment considered in the
सारी उन्होंने judgments quote की थी. But I think what I liked about it is that it sort of gave an alternative vision to the top-down federation approach that we had. This idea of cooperative federalism कि सारे तकरीबन बराबर हैं और ये evolution होती रहेगी इसकी. I did some comparative analysis. So the government of India, the Constitution of India has a very interesting clause in it. It has Article 253, which copies the Government of India Act 1935. It says that notwithstanding anything in the foregoing provisions of the chapter, Parliament has the power to make any law for the whole of part or any part of the territory of India, or for implementing any treaty or agreement. So it says very clearly that Parliament has the power to do so. But there is a difference between the Federation of Pakistan and the Union of India. These words are very indicative. India has, I don't know, how many states, how many languages, how many cultures, how many basins. And I think that I came across a passage somewhere talking about federalism in India, that Nehru realized that the various forces that made India was such that if they were not held together, they would dissipate apart. That the union had to have a control over the states. And that's an example of the union exercising control over states. That we will still make treaties for you. You have to be part of us. But our constitution is a federation. And so just reflecting a bit on the differences in these words again gives some meaning to what cooperative federalism could be, perhaps. Next slide, please. We also had a look at Germany. Germany is another federation. Each lander has its own constitution. We also read up in Belgium. Belgium has a fantastic federal system where every province or canton is more or less independent. And as a result, Belgium has the most number of foreign offices of any country. हर छोटे cantonment या province का एक वो अपना बादशाह होता है और वो अपनी क्या कहते हैं, he can have his own embassy anywhere in the world. They're fully independent. They can enter into international agreements with other countries. So it's an example of a federal system where the federation has full power. The federal entities have full power even in foreign policy. But Germany is slightly different. Germany has some controls. Insofar as the provincial federating units have power to legislate, they may conclude treaties with foreign states with the consent of the federal government. So that's another example as opposed to the diametrically opposed to India. कि यहाँ तो province भी international agreement enter कर सकती, India में नहीं कर सकती. And in between these two is the example of Canada. Because Canada is another federal structure. And I think Canada is an attractive example because it's also a sort of post-colonial country, federal country. It has that experience with the crown and parting with it. And so there's some very interesting international constitutional law that was developed in Canada as a result of this. But what they do have is a system where Parliament and the provinces cooperate with each other in the implementation of an international agreement. That at the time that the document is presented in Parliament for ratification, if it contains provincial elements, the provinces are invited to participate in the ratification process. And then it is thrashed out how the responsibilities of the federation and the provinces will be worked out. Because a lot of treaty responsibilities are only reporting responsibilities. They're not actually substantive responsibilities. तो वो तो एक दफ्तर में भी हो सकती हैं. Next slide, please. Okay, so moving from who and the questions relating to who comes the what. And I'm going to try and wind this up quickly. We found, next slide please, that under the Pakistan Environment Protection Act, there are 14 international agreements which are listed in the back as a schedule, and the federal government had power to make rules to implement these international agreements. This is the what. These are the international agreements we think about when we talk about multilateral environmental agreements. Next slide please. मैं थोड़ी सी रिसर्च कर रहा था और मुझे वेबसाइट मिली इंटरनेशनल एनवायरमेंटल एग्रीमेंट्स की. इट्स अ डेटाबेस. इसमें लिखा हुआ है 288 एग्रीमेंट्स पाकिस्तान ने साइन की, जिसमें 31 सिग्नेचर्स, 71 ratifications. So that list of 14 environmental agreements, I don't know what logic makes those 14 more important than the other जितने 61 हैं. What are we implementing? And so the question is, how do we implement as well, which is part of the what are we implementing. Next slide. We have identified the following ways that Pakistan has quote unquote ratified agreements. Please tell me if I'm wrong here. This is really the result of my research and really the heart of the question I'm bringing to you. कि एक तो है हम जाकर साइन करके आ जाते हैं और हमें कहा जी हमने मुआहदा साइन कर लिया. ये एक तरीका है. जैसे हमने वियना कन्वेंशन को साइन किया है और उसके बाद कुछ नहीं किया. Which is interesting, right? I found that out. Okay, it's not properly ratified. We just signed it and came back. So we don't know what to do with it. Then we have implementation through executive action. So we have the Ramsar Convention. Ramsar is a city in Iran where the World Wetlands Convention took place in 1973. The wetland is a type of forest, it's wetland. And you have to protect it. But there's no act that implements the Ramsar Convention. There are no rules that the government of Pakistan have made to implement the Ramsar Convention. But there are notifications issued by wildlife departments of the provinces declaring as many as 19 sites in Pakistan as Ramsar sites. So that is implementation by some sort of executive action. And the same is true of the Basel Convention, which prohibits and regulates the transboundary movement of chemicals and hazardous substances. There are no act on Basel, there are no rules on Basel, but under the import policy order उसमें लिखा हुआ है कि all the chemicals in the Basel Convention cannot be imported or exported without a NOC from the Ministry of Climate Change. Enforcement हो गई by notification, by insertion into import policy order. Stockholm Convention on persistent organic pollutants is another example of this. A third way is something the former Minister of Law told me कि जी ratification का मतलब है cabinet ने approve कर दिया. ठीक है? Next. So in my experience, I found these various reasons given. Here there's a resolution passed by the National Assembly. If you look at the federal government rules of business and you do a control F for resolution, you will see that the provision relating to resolution says resolutions including resolutions for the implementation of international agreements. It's in the rules of business. So तसव्वुर ये है कि शायद National Assembly की resolution से भी शायद because rules of business में ऐसा तसव्वुर लिखा है. Next. Incorporation into legislation without specific mention in the legislation. जैसे we have the Pakistan biosafety rules which regulate genetically modified chemicals and organisms in Pakistan. Most of the cotton in Pakistan is genetically modified. We've signed an agreement called the Cartagena Protocol which regulates this, but the Cartagena Protocol isn't on the 14 international agreements which are scheduled to PIPA. मगर उसका हमने rule बना दिया है. The Pakistan biosafety rule implements the Cartagena Protocol, even though the Cartagena Protocol isn't listed in the list of 14 international agreements in PIPA. But हमने कर दिया. Same is true with the Antiquities Act, which incorporates the World Heritage Convention or substantially incorporates provisions of the World Heritage Convention into national law, but there's no mention of the convention in the legislation itself. Next slide. Then you have government empowered rules, जैसे PIPA 1997 है. लोग हमसे कहते हैं अच्छा वो क्लाइमेट चेंज एक्ट बन गई है ना, क्लाइमेट चेंज एक्ट 2017, उसका आखिरी सेक्शन है द फेडरल गवर्नमेंट मे मेक रूल्स फॉर द इम्प्लीमेंटेशन ऑफ इंटरनेशनल एग्रीमेंट्स लिस्टेड इन द शेड्यूल. तो उसके शेड्यूल में पेरिस एग्रीमेंट लिखा हुआ है. तो हम अब लोगों को कहते हैं कि हमने पेरिस एग्रीमेंट को रेटिफाई कर दिया, मगर उसके ना कोई रूल्स बने हैं, ना कोई उसका एक्ट बना है, ना कोई इसकी नोटिफिकेशन हुई है. मगर लोग अगर पूछते हैं हम कहते हैं जी हमने कर दिया. So that's the same with PIPA 1997. There are 14 international agreements in the schedule to PIPA. एक पे rule नहीं बना, लेकिन अगर कोई पूछता है हम कहते हैं जी ratify हो गया. Next slide. And last but not least, what we actually consider ratification when Parliament passes a law saying ये कानून उस agreement की वजह से हम बना रहे हैं, which is the Pakistan Plant Protection Act, which incorporates the International Plant Protection Convention of 1951. So what are we implementing? जी ये भी समझ नहीं आती. Next slide. एक और चीज़. So this is PIPA 1997 with the 14 international agreements. Punjab has copied PIPA 1997 and Punjab Assembly has authorized the provincial government to implement 14 international agreements by rules. Punjab has not. You'll notice that rule number 8 is the Convention on the Law of the Sea. जब आप कंट्रोल सी वाली हरकत करते हैं तो आप एक लैंड लॉक्ड प्रोविंस को इख्तियार दे रहे हैं कि लॉ ऑफ द सी पे कोई रूल शूज बनाए. नेक्स्ट स्लाइड प्लीज. अच्छा केपी में इन केपी हैज़ मेड अ एनवायरनमेंट प्रोटेक्शन एक्ट जिसके शेड्यूल में देयर आर 19 इंटरनेशनल एग्रीमेंट्स. अब उन्होंने कौन सी उठाई है मुझे नहीं पता. You look at the Balochistan Act, there are 32 international agreements that the government of Balochistan can implement. So what are we implementing? What are the mechanisms involved here? What is very clear is that there is no mechanism after the 18th Amendment for the Federation and the provinces to interact when it comes to the implementation of international agreements. There is none whatsoever. So we are getting these sorts of weird results as a result. And so I would put forward as a potential solution the Canadian model, which is a policy that the National Assembly has adopted where you speak to the federating units when you come to these sorts of things. Because this is far too important to be ignored. For example, Pakistan benefits from GSP Plus, which is a European preferential trade status, which is contingent on us implementing and being able to say that we follow certain international human rights, labor and environmental agreements. जो उसका ऑडिट अगले साल होगा वो substantially not in compliance. We could lose GSP Plus unless we fix this. Now I understand that work has been done at the Ministry of Law and Ministry of Foreign Affairs. Committees have been formed because of GSP Plus looking in the implementation of international agreements. But they were looking at human rights laws because that's where the politics was. Right? I was looking at environmental laws and these are the sorts of issues that cropped up when I was looking at them. So I really thank you for your attention, allowing me to ask these questions and raise these issues, and I do look forward to taking part in substantial discussion as well. Thank you.